condition called vitiligo that was not a disabling condition, but because the person saw the pigmentation, the discoloration, the pigmentation of the person's skin, the person assumed, the housing provider assumed they did and said, no, we don't want you, slammed the door on them. Right. So that's the kind of thing where someone who's regarded as having a disability but may not meet the definition per se of a disability does under the Fair Housing Act. So it's very broadly defined. It's broader than the Social Security Act or the American with Disabilities Act. And I want you to look at, this is a list of, oops, sorry, I think I passed it. This is a list of all the mental and physical conditions that one might have that might be considered an impairment. It's super, super broadly defined, and this is not an exclusive list. So there may be other conditions that are on here that are not listed, but I want to pay close attention to alcoholism, persons who are actively using alcohol, or if you had a prior drug addiction and you're in recovery, you're considered disabled under the Fair Housing Act, except there is an exception, and that is if you made or you distributed drugs. You made or sold, manufacturing or distribution, and you're in recovery, you don't get the protection of disability under the Fair Housing Act. So yes? You're going to have to read that. Okay, the limits are physical or mental impairment, orthopedic, visual, speech, hearing impairments, cerebral palsy, autism, epilepsy, cancer, heart disease, diabetes, HIV/AIDS, mental retardation, emotional illness, learning disabilities, alcoholism, prior drug addiction, and current users are not covered by the Fair Housing Act. That is not considered to be in recovery. Oops, sorry. Okay, what is a major life activity? So if it substantially impairs one or more major life activities, what does it include? Functions or activities that are central importance to daily life, such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, working, just about anything you do. Again, not an exclusive list. Whoa, trying to do this without. Sorry, guys. Okay, make sure that I didn't. Okay, so what can you do? Under the Federal Fair Housing Act, under 42 U.S.C. Section 3604, you can request a reasonable modification, which is a request for the physical alteration of your premises, adding a ramp, adding grab bars, widening a door, or you can ask for a reasonable accommodation, which is an exception to a rule, policy, procedure, practice. So it's very broadly defined. We're going to talk about the difference between those two. Oops, what did I do here? HUD guidance on reasonable modifications and accommodations. The best thing that you can do, if you forget everything I say today, you should go check out these. Okay, I don't want to turn this off, but what do I do to remove this? You can check out the HUD DOJ Guidance, the HUD Department of Justice Joint Statement on Reasonable Accommodations and Reasonable Modifications. It is one of the best guides that the Department of Justice and HUD jointly wrote. And you can go to this right away, and you can go on that. And even if you just get on Google and link Joint Statement on, it'll just fill it out for you. But please read it, because it kind of gives you a step-by-step instruction on how to address these issues. There's also a really good one for design and construction, the same thing. It is super. So if you have a chance, please, please read it. Here's an example of a reasonable modification. I talked about those. Physical alteration of your premises. You can request ramps, widening of kitchen, bathroom, or bedroom doors. You can request installing of grab bars in bathrooms. And we'll talk a little bit more specifically about those things. Oops. Who pays for modifications? If you are a federally funded housing provider and it is not a huge financial burden, you will be required to pay for it. So it has to be reasonable. If you are not federally funded, you should grant the modification, but the private individual should pay for it. They are responsible for the cost of the modification and for restoration, unless it's something like widening the doors that adds value and doesn't make sense to restore it. And if you go to the HUD DOJ statement on reasonable modifications, there are some really good guidelines. One, the modification needs to be done in a workmanlike manner. So typically it doesn't have to be done by a professional, but it should be done in a professional manner. It should be safe. And in some certain instances, there may be code requirements that you must meet, and they'll talk about that a little bit more tomorrow. About there might be code enforcement requirements that you will want to talk to your city or your county or state about. Okay. Oops, did I miss one? Okay, nope. Sorry, I'm having issues. Okay. I really like sample forms, and under the HUD DOJ statement, just like David Penny said, just like Sarah said, you are not required to use any forms. You can make a verbal request. As a housing provider best practice, you should certainly make sure that you document that request so that you have it documented, but they're not a tenant, or if you're a homeowner applying for an exception to your CC&Rs, they're not required to use your forms. And so we give you some sample forms. You're not required to use our forms. And the reason that we have them is just so that to facilitate that discussion. But do make sure that your forms comply with the Fair Housing Act. Because as David said, there have been some concerns about certain wording that we're using on forms. And what happens is, per se, those forms might not be a violation of the law, like under penalty of perjury, HIPAA releases, things like that. Or they might not be a violation or an inquiry to the nature and severity of the person's disability. More likely than not, you're going to run into a pitfall if people aren't properly trained on accommodations and modifications, or the tenant or the consumer misperceives what you're asking them. They might accuse you of engaging in discrimination. And so that's why you want to be really careful about the forms that you use. So we've worked with Northwest Affordable Housing Management Association and some of you in the community to come up with sample service animal policies, to come up with sample reasonable accommodation policies. So we're not reinventing the wheel, and we're all on the same page. So I'm hoping that we can all get to the point where we're using the similar forms and similar agreements or similar rules, so that we're not having the discussions over and over again. And so we provide those for free. And some of you will want to use your forms, and I will say that's fine, but I'm going to give you some examples of things that I think are best practice that we've worked out with other housing providers or other housing provider attorneys or advocacy groups, and I hope you would take them into consideration. So if you need those, let me know. Okay, examples of reasonable modifications, right? We're asking for exceptions to policies, practices, procedures. And these are, everybody knows, we've talked about the companion animal already. We've talked about changing the date that rent is due, but you might want to ask for permitting a care attendant to live with you to get access outside help. You might want to ask an agency to help you with something to meet the terms and conditions of the lease. You may want to ask for someone for alternative communication devices like large font, or as we heard earlier today, using a relay service to make sure you can communicate with persons who are hearing impaired who might apply for your services or during their tenancy. Or parking spots. That's usually the biggest question we get. Oops. Okay, when someone asks for a reasonable accommodation, you cannot inquire into the nature or severity of the disability. But what we must know is that if someone has an obvious disability with an obvious need for that accommodation, they are not required to ask for it. They're not required to give you proof of need. And David gave a very good example. I have a seeing eye dog, and you're a no pets complex, and I have a sight impairment. I don't have to ask for an accommodation because you know why I need that animal, right? I'm sight impaired. But let's say when you have someone who has an obvious disability or a non-obvious disability, but you don't know why they need their animal. And typically that's in a comfort animal situation or a companion animal situation. Or sometimes if you don't, someone says, oh, I need an accessible parking spot right in front of my door, but they're not in a wheelchair, they're not using French canes, they're not using crutches, and you don't know why they need it, you may be able to ask for proof of need. And so we'll talk about that. Oops, sorry. Proof of need. Who or where can you get one from? So this is also broadly defined because there are some areas in our country and in our state where there is no medical provider. There is absolutely no medical provider. Furthermore, there are people who can't afford them. And so we have to be mindful that sometimes in Salmon, Idaho, or in Idaho City, they're not going to see a doctor for 6 months. They're not going to have access to them maybe through telemedicine, maybe through something else. So the Fair Housing Act says, hey, if I want to have someone who has a non-obvious disability or an obvious disability, but I don't know why they need, remember that parking spot, they can ask for proof of need, or you can ask them to get proof of need from any list of people, someone who intimately knows of their disability as defined under the Fair Housing Act and their need for that animal. So it can be an RN, it can be a physician's assistant. It might be the mail person. The mail person might be the best one to know that they can't physically go get their mail unless it was right posted on their door. But they'd have to be able, if they were coming to me, to testify that they knew of that person's disability and the need to have that mailbox put right attached to their door. Okay? What the person who's verifying should never do is disclose the nature and severity. Some of you will have gotten something from a medical provider, even though we have HIPAA, that discloses every diagnosis the person has ever had. Okay? I've gotten those. And we try to help with those. And what we suggest to you as housing providers, or suggest to you as tenants or consumers, is to, if you're the consumer or tenant, make sure that your qualified professional or person in the position to know, because it can be a person in the position to know, does not disclose your disabling condition. Go back to them and say, can you just say I have a disability as defined under the Fair Housing Act? That's why our form, that's why some of your forms contain the definition. It's super helpful. They correct it. Sometimes we as advocates correct it, but sometimes you as a housing provider, you'll get that form and go, I don't want it, because if I have it and I have a fair housing complaint and it's in my files, guess what? In discovery, through litigation, or from a fair housing investigator because they have subpoena power, they might get a hold of that and say, hey, the tenant has said, hey, they've discriminated against me. I knew they knew of my disability. They talked about it to everyone. They treated me differently after I shared that with them. They talked about my bipolar, my schizophrenia, my epilepsy. And then they started treating me differently, and it's actually in your files. That might be evidence to corroborate their allegation. And so what's the best practice? Well, there's kind of two schools of thought. One of them is hand it back to them. Document that you received the proof of need and give it back to them. The other school of thought is redact the copy, meaning black out all the diagnoses, right? Make them initial that you blacked it out. You put the blacked out copy with the signature on it in your file. You hand them back the one that was blacked out, the original that was blacked out, and you give it back to them. So those are the two schools of thought. You can do what you think is best, or what your senior officials and your complex think are best, your management. But safely, I would give it back and document. That's what I would do. But I know that there are two schools of thought, so I think that's important to know the differences. So never disclose the nature and severity, and never ask about the nature and severity. If someone goes to apply and they're saying, oh, I need this parking spot close to my unit, you're not going to ask them what their disability is. Can I have medical documentation? Any of those sorts of things. You're going to just say, do you have a disability as defined under the Fair Housing Act, and do you need this accommodation for that? And they will ask you either for forms, or you can tell them where to go get them, right? But they don't have to use your forms. But you have to show the relationship between the disability, the accommodation, and the need for it in the housing and how it will affect it. Okay? We talked about that already. Again, I'm just going to keep emphasizing that HUD DOJ statement, because if you forget everything I say today, it's a great resource. What can you do? Well, remember, we can do verification. We just talked about that. You can also verify that they're able to pay rent, that they're able to comply with the rules of your program or of your housing unit or of your homeowners association, and you can report required information. A lot of you are federally funded providers, lenders, whatever you are, you can require that they can comply with your terms. What you can't do, we already talked about nature and severity. You can't ask about what their disability is. Why are you on SSI? Well, you don't look disabled. Well, I need to see your medical records. All things that people say and still say, and we're advanced, so we don't need to do that. Please, 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 don't directly ask the qualified professional for verification. Don't go to them, don't take that and go, can you waive your rights, and I'm going to go contact your medical provider. Is it a per se violation? As long as you're limiting it, You probably can, but I'm going to say it's not best practice, because usually what we find is those of you who give HIPAA releases, or those of you who say, I have to verify this directly from your medical provider or person in position to know, tend to either get or receive from the qualified professional all the person's diagnoses. And then if there's that risk that if there's ever any controversy about how you treated that person with a disability, they're going to say, you asked them, and they told you all about my diagnoses. And we're really trying to redirect that and take a different approach. Just like David said, it's best if you give the form to the tenant or to the homeowner or to whomever's in the housing program and have them go take it to their qualified professional or person in the position to know. Don't charge extra fees or deposits for service animals, for wheelchairs. These things sound silly, but people still do it. People still do it. And don't outright deny accommodations or modifications if they're reasonable. And Jennifer has a question.
I have a tenant with an obvious seeing impairment who has requested to use her stove that has raised marks on it. Does she need a written request?
Can you repeat that again?
I have a tenant with an obvious seeing impairment who has requested to use her stove that has raised marks on it. Does she need a written request?
So we have a person who has a reasonable accommodation to use her raised stove because of her sight impairment.
Correct.
To me, that sounds like an obvious disability with an obvious need, and I would say no. And there might be something with, and I'm going to say this all the time because I like to have disclaimers because we're lawyers and lawyers love disclaimers. Unless I have more facts, I can't give a more complete answer. So also feel free to call us because there might be facts and circumstances in which that answer was not complete. All right. So that's a lawyer answer right there. So you want to know, when is it unreasonable, right? When is it unreasonable? Well, here's your three answers. Undue financial burden, administrative burden, or it fundamentally alters the nature of the program. And since we're going to talk about service animals, when could it be undue financial or administrative burden? So I ask for my service animal, and I provide a proof of need because it's not obvious, and there's not an obvious need of why I need my service animal. And then guess what? I ask you if you could build a potty spot out in your complex or in the homeowners area for the homeowners association just for me to potty my animal. I want you to create a place because it's hard for me to go and potty it in this one spot. But I want to have a designated potty spot. Could that be a financial burden or administrative burden? Right. It could be very costly to rip out the lawn, make sure that where you're going to have that potty spot, that play area for the dog is, or cat or whatever it's going to be, is accessible, because you have to have it be accessible, right? Okay. And so that might be not only financially burdensome, but the administrative purposes of having to go through that process of getting everyone involved and trying to make sure that you create that in a way that's accessible for that person, that might be problematic. It's also probably a service you don't provide normally through your housing provision services, right? So it would be an alteration of the nature of your program. And so that might be one that you could say, you know, I can't do that, but best practices under the HUD DOJ statement, just like David said, you're going to have an interactive discussion about what else you could do. What else could you do in that situation? There's a potty pad from Bed Bath & Beyond, might be. They pee in the potty pad from Bed Bath & Beyond. And she said they go and they pee on it. Never heard of this? This is good. See, that's why we have these. So I learned something new today. Or you might have a designated spot in your area. Or what else? Some people have accessed community members to help, right? Some of you, I mean, I know you. I've contacted you and said, hey, can you help this person? So think outside the box. Here's a creative solution today that I wasn't even aware of. So points for you. Okay. But what you should never do, what you should never, ever, ever, ever do, because we love that interactive process, it doesn't mean you can't deny. It just means you don't want to outright delay. Well, it's going to take us about 4 months to decide whether you get that accessible parking spot. Probably not a good idea. You're not going to outright deny, I'm sorry, we're not going to give you that accessible parking spot, even though they're in a wheelchair and there's no way they can get to their assigned parking spot in another area. No. Or ignore it. Oh, you know, we're going to get to that. I think I put it in the shelf about, oh, I don't know where it is. You know, those are the things you hear about and you think it sounds silly, but some people say, oh, I just forgot. And so don't do any of those things because that is the same as just denying. So make sure you engage in an interactive dialogue. Right? I already said all that. Another thing you want to do, talk about it, and have the ideas for the alternative accommodations. If it is unreasonable, if it is financially burdensome, have the idea come from the tenant or the homeowner or the person in the housing program. Sometimes the best solutions come from them, and that way you're not inquiring to the nature and severity of the disability. If you're having the good idea come from them. Because I might say, well, what else could we do besides providing you a whole new potty area? And she might have said, hey, well, I've got these potty pads, and I can buy them at Bed Bath & Beyond. I can use those instead. So really creative solutions come from consumers because they know what they need, right? And make sure you document it. David, everybody today has all said document it. If you don't document it, it didn't happen, right? Okay. Again, I love these websites because they have lots of resources on them. So please use those. Okay, we're getting to service animals. I want to make sure we get to it because we have plenty of time, lots of questions. Sorry, we have a question? This whole next section is all service animals. And and we have a question here in the back. You, sorry. The question was, when can they ask for a reasonable accommodation and when is it no longer reasonable? During the community, during the termination of a lease, they're asking to be released from the lease. So let me give you a general, again, my disclaimer, okay? But in general, I can ask for reasonable accommodation anytime during the period of my tenancy, during the period of my homeownership and dealing with my homeowners association, and anytime during the period of my participation in your housing program. Anytime. Anytime. Right up to, I'm in the courthouse steps, I see David Penny, I walk over to him, we're in mediation because he's great about mediation. David, I got a reasonable accommodation request for this eviction. Oh, you know what he's going to do? We're going to engage in an interactive dialogue and talk about it because that's what he does. So anytime. And we're going to go through the analysis of, is it reasonable? Is being released from the lease reasonable? And we're going to look at, they're going to ask for reasonable accommodation because they have a disabilities defined under the Fair Housing Act, right? They're asking for an exception to maybe have a year lease, right? So I have a year lease, I'm asking you to release it prior to the end of my 12 months because, and they're going to say, I need to be closer to my therapeutic treatment for my disabling condition. My life-saving treatment. Usually I will typically see exactly that request. I've had colleagues who've needed to go or consumers who've needed to go to a Mayo Clinic because they have a terminal illness or for somewhere similarly situated to go move by someone who can help care provide for their medical condition. So really think about how you're going to process that. Will there be costs incurred? There might be. How can we mitigate those costs? How can I help my consumer mitigate those costs? And how can you help mitigate those costs? And one of the things is they give you that kind of notice, you're going to start looking for someone to re-rent it. You're going to mitigate your damages by trying to help them find someone to re-rent it. A good renter just like they were, right? Or a good housing program participant. So it's those kind of interactions that when you're stumped, like, how can I do this? Call us, call Christina Miller, call Charles Jones right there. Sorry, Charles, raise your hand, Charles. He's a good problem solver right here. John is here, Myers, Brian Dale. you know, all your city people that are here. We've got our city people here, Rihanna. We've got Jennifer here. They are really good problem solvers. And so call them to go through some of those things. How can we problem solve this? We do it a lot of times with mediations on reasonable accommodations. They're really conducive to that. So does that help answer? Hope I answered that. Okay. And so the fee, we want to look at those fees, and don't want to do it case by case because I don't know more information about it. But if you re-rent it right away, what fee would be incurred? Because you're going to get your rent paid. There might be the cost of advertising. I get those. There might be that cost, but you're going to want to look at whether or not it is a financial burden or it really is a cost to you. Is it really a cost? Oh, it's going to cost me, this is a really terrible market. I'm never going to find anybody. So that might be a financial burden. But here's what we're going to do to work it out. It might not be. It might be de minimis. You might already re-rent it really quickly. What fee did you incur? You put it on Craigslist, it was rented the next day. So, you know, we're going to look at it on a case-by-case basis. So I'm not going to say this is a blanket, do this or that, because really a lot of these cases are weird, but they're really case-by-case. You're going to look at the facts and circumstances. So the question was, do we wait to assess fees till the day they leave? I would have to look at whether or not, on a case-by-case basis, seeing whether or not, because they're asking for an accommodation. It's just like, you have your no pets policy, or you have a pets policy where you charge a deposit. Guess what you have to do? You have to waive fees. Is it a cost? Some of you are going to say to me, yes, so. That's why we have this conversation for an hour, because I get frustrated, right? That's why we have this. But there's going to be times when we have to work on solutions to waive those fees because they act as a barrier to a person with a disability. And not in every case. And it's not in every case that you can't charge someone for damages when they've damaged the complex. It's a case-by-case basis. Okay? All right. We're not here to talk about ADA service animals, which are dogs and miniature horses, because I'm sure Dana and Amy Howe are going to talk about that tomorrow, or they might not, I don't know. But if they do, here's my like 1 minute primer on it versus Fair Housing Act. This is what I'm here to talk about. Fair Housing Act service animals, okay, and companion animals. And they're not limited to dogs and miniature horses, okay? Okay, under ADA, the American with Disabilities Act. If I was coming here today and the manager from this building came to me, these are the only 2 questions they could ask me with my service animal dog, or service animal, right? They could ask me with my equine or my dog. Is the animal required because of a disability? And what work or task has the animal been trained to perform for you? Not what my disability is. Why do you don't look disabled? None of those things, okay? But guess what? Some of us have a misunderstanding that they have to have certification, that they have to have documentation, that all they have to be is individually trained. I don't have to show you that I went to California and got them professionally trained from some service animal school, okay? Emotional support animals, comfort animals, assistive animals are not covered under ADA. They relate to a physical disabling condition. I could have an emotional impairment or disability that manifests something physical about me, and I will actually qualify because of my condition has a physical component to it. Okay, so be very careful. Okay, that's enough. We've talked about that. Okay, yeah. So the question was, are PTSD animals covered under the Fair Housing Act? Under the ADA. And Dan is shaking her head yes, and also bowing, because you better do that. And you don't want to know why, because there's a lot of, usually case law or interpretation, and also the physical manifestation of having PTSD. okay? So be really careful when you think you're going to deny something. You might want to get help from the experts like Dana, the Disability Rights Idaho, your Living Independent Network Centers, people at Amy Howe, is she still here? You want to get somebody a second opinion, because we've heard all across the state where people have denied people access to airports, to grocery stores, to department stores, so be super duper careful. Okay, David already said this. Service animals are assistive devices, or Sarah said this. They're like wheelchairs, canes, French canes, crutches, okay? Under the Fair Housing Act, you might hear several different terms. Service animal, support animal, assistive animal, comfort animal, emotional support animal. They're all the same. They're all the same. They're going to be used interchangeably, and you are not going to say, well, is it a service animal or a companion animal? Does one denote something other than the other? Usually people use service animal or support animal for physical disabilities and comfort or emotional animals for persons with mental disabilities. However, sometimes they don't. Sometimes they'll use support animal. Sometimes they'll use service animal. Okay, we have a question right here.
So for the emotional support animal, I've heard, and then it hasn't happened yet, but I've heard like someone have like an emotional support ferret.
Yeah, we're gonna. So she's ahead of the game, and I paid her money. I paid her money to ask that, but remember that's in a couple slides coming. So ask it again. We're queuing that up. So good question. Yeah, service animals can be any type of animal. Any type of animal, but we'll talk about some exceptions or limitations, okay? So she said, yes, there can be. The question was, can there be service animal ferrets? Yes, there can be service animal ferrets, but we'll talk about those different types of service animals, okay? When can you ask for one? I asked her in the back to queue me up for this, and that was, you can ask them at any time. Before, during, toward the end of your tenancy, toward your end of the housing program, toward the end of your home ownership. But I'm going to tell you what I think. This is Zoanne Olson. This is not anybody. This is not Intermountain for Housing Council. I think you should let the housing provider know before you move in. That's just my belief. I think you should, okay? There are going to be advocates who think because it is a service animal or companion animal that you do not, because it is an assistive device and it is not a pet. So you're going to see two schools of thoughts on that. There may be other schools of thoughts. I'm giving you those two. I think that typically you should let them know ahead of time, and then you should, if you need help, you should ask Intermountain for Housing Council if you don't know how to address it, or your provider or HUD or the Idaho Human Rights Commission, okay? Again, it can be any size, weight, breed, any kind of animal, okay? Any age of animal, except when the state or the county or the city have an imposed ordinance for vicious breeds or exotic animals. And then guess what? We have an added layer. We can ask for a reasonable accommodation to the state, the city, the insurance company, the code enforcement for an exception. And it is incumbent upon you as a housing provider, if that's your rule, you should assist with doing that. There are communities in the state of Idaho that actually have ordinances that prohibit certain breeds. And if your insurance says, hey, you know, it is a financial, we are some breeds we're not going to allow in our complex, then you as a housing provider or you as a homeowners association should ask for an accommodation to that. And HUD has actually, again, very helpful guidance on that. Super well-written document right there that please have access to. And you can ask for an exception. And if it is a financial burden, you can show that you can't get liability insurance anywhere else, or they would cut you off, then it may be a financial burden. But you did what you were supposed to do. And I don't know, Charles, have you had any of those cases where with the insurance? Yeah. And usually what we found is the insurance company grants it. They'll say, yeah. So they've been cooperative. So I see a couple hands, and so I want to make sure we answer these questions right here. So the question was, if the person has a larger animal, can you require that, I'm assuming it's a service animal, can you require them to be on a lower level? No. You want to make sure that you're allowing the person to choose where they live. So you give them the options. If they choose it, yes. I lived in a multi-story housing complex in Tacoma, Washington, and we had pets and service animals all up and down the most giant high-rise in the whole world. Oh, the miniature horse. So her question was, what if they have a miniature horse? I'm going to apologize, but probably the same answer. Yep, because sometimes they're usually typically really teeny tiny. But in certain instances, it might not be reasonable. And I'm going to defer to Jennifer and Jerome and Eric Kingston for the intersection tomorrow of state, city, and county code. We have a question in the back. Yes. You could. So you can ask for an exception, and cities are granting them, and counties are granting them for vicious breeds. They are granting it for if there was insurance required. So in both cases, you can. Yeah. Okay. Oops, sorry, didn't. Oh, oh, I'm sorry. I forgot. I apologize. So the question was, in emergency housing, typically that is set up in very tragic situations like Katrina or earthquakes or whatever, how would you best apply a reasonable accommodation policy for service animals? And I would treat it just like you do with regular housing, in that if they have an obvious disability with an obvious need, you're not going to make them get a verification of need. And if it's in a situation where you're setting up a shelter and you're not sure that they can prove it yet, I would have a conditional provision, because if you deny it and they can show that they need that, what was it, the bunny, the ferret, the rat, and you deny it, then you're going to may face fair housing complaint. So have a process in place, and typically people who have service animals have a proof of need, have a verification that they would bring with them. They do. And I would set up with, if you don't have the facilities, every single community in this state and most states are required to have some sort of fair housing, ADA, 504, 508 for your computers, compliant process to deal with this situation. Even complexes for fire code should have an ADA 504 compliant evacuation plan for your building. So check to see if you are fair housing compliant, because some are not. And we had one housing provider, when we went to a meeting, and they said, well, how are the people, they had an elevator, how is everybody supposed to get down to the bottom floor? What are we going to do? And the manager said to everyone, you're going to slide down on your butt. I don't think that was the best fair housing compliant, ADA compliant, 504 compliant statement. And it was really, people they're scared. And they want to be able to leave and escape a fire or earthquake like everyone else. So guess what? There are really good resources. Jennifer and Eric have suggested we'll post some of these with the ADA Fair Housing 504 compliant policies, because you can get them right online. They have whole evacuation plans. They have setting up for shelters dealing with service animals. And so I'll make sure that I get that to Jennifer and Eric. So how many service animals? This is small. I'm not going to read all of it because I don't like to read it. I just wanted you to have it so you could remember it later. But my rule of thumb is, and this is Zoanne Olson again, because remember we have lots of lawyers in the world, lots of interpreters. I'm going to give you what I think, and then I'm going to give you what other advocates think. Okay? I think that you should have, as a person with a disability, you should have a verification of need for each service animal, for each disabling condition. You should have a relationship with that animal for one condition, okay? But I can be persuaded by a qualified professional person in a position to know that you might need two. You might. There's a federal case called the Janish case where the lady had two cats, and they worked together to ameliorate the effects of a disability. And they had a great proof of need, and they had a great expert when they testified in federal court. There are advocates who think that multiple animals who have a symbiotic relationship, means they work together, To ameliorate the effects of your disability, you only need one proof of need. I'm just telling you what I think. I think it's stronger if I am going to go to court or I am going to file a complaint and Charles gets it. I want a proof of need related to each disabling condition for that animal. Okay? So, how many service animals can you have? That's my answer. Is it helpful? No, it's not like pat. But when I see rules of housing providers who say you can only have 2, I give an example of there's a family of 4, a husband and wife who both were sight impaired. They had children. They adopted children. Both children were sight impaired. They all 4 had seeing eye dogs. And I said to them, so who in the family doesn't get their seeing eye dog? And they're like, oh, okay, I get it now. Okay? So sometimes when we have blanket rules and we don't look at them on case-by-case basis and the creativity that a reasonable accommodation allows both in and out, we tend to violate the law. So look at it on a case-by-case basis. Okay? And I had a question somewhere. No? Okay, okay. Yes, we do. Right back there. Thank you for asking that. Yeah, so the question was, are you required to pick up after your animal, your service animal, to have care and control? I'm just going to extrapolate off of that. To have care and control over your animal just like you would a pet. Well, what David said was actually correct. You should have separate service animal policies. Okay? You should have separate service animal policies. Yes. You can require that a person with a service animal pick up after the animal, not do damage, not be noise unless the noise is related to the service they provide. So if they intermittently bark because of danger or to warn the person they're going to have a seizure, you wouldn't know that, but there are reasons that people have their animals make noise. You can require it. If the person needs help, you're noticing that they're not in compliance because the animal, I'm going to say they're pooping, they're making a mess, you might be able to give them a lease violation, or you would be able to give them a lease violation if they are damaging the property, if they are doing things that violate your lease agreement. And then you may want, when they come in to talk to you about it, to ask them, if they ask you what they can do to address it, give them an opportunity to cure. Engage in that interactive dialogue and say, hey, you know, we want you to have your service animal. We love everything that you're doing. We love having you here. And they say, well, what can I do to correct it? Give them an idea. Well, what can you do to correct it? Well, I think I can go get help from so-and-so or my family member to make sure I pick it up more regularly. Or can I have more time? Can I make sure, because my son doesn't get off work until 5, could he come pick it up after that, the poop? And you're like, yeah. Or can he help me clean? Because maybe sometimes we have a lot of people that we need help from that are hoarders, where they have piles and piles of stuff. And we've had to call in community groups to help us, 1, get more time to get them in compliance. And 2, we want everyone to be good tenants. And so they've come in and they've cleaned up the place and they've shampooed the carpets and they've done everything that they're supposed to do to get them in compliance. So yeah, you can have care and control requirements. And one thing that we'll talk about in a minute is, you know, leashes and so forth. Does that answer your question? Sure. So the question was, let's say you have a service animal or a person with assistive animal, whatever, and they bark all the time. And so I'm going to give you the process, the best practice process I would engage in. And those of you who are also want to give other suggestions, please feel free to do so. I would go talk to the tenant and say, hey, we have some documented concerns, and I would make sure that you would go talk to the other tenants, hear what their concerns are, go talk to the tenant that was being complained about who had the service animal, make sure it's not really about that they just don't like people with disabilities, but actually about the dog barking. You would want to make sure that they have some, or whatever, that they've had some documentation, some sort of written requirement that they've documented it, that they've recorded it, that sometimes people have filed a police report, not that I'm encouraging that necessarily before trying to problem solve it, but they've had some sort of documentation. Then you talk to the person, and the person's saying, yeah, I got this is my new service animal, we're just getting used to it, or they might just, if they ignore you, then you might want to give them a warning and then proceed with your eviction policies after you've done the progressive, as David would call it, the progressive notices to warn them. But talk to them about it first. See how they can come up with an idea to get into compliance. If it continues, then what is your process? You might go to eviction. If you can't resolve it by trying to give them the opportunity to correct it, to come into compliance, then the last resort might be eviction. But during that process, get help. Get them to think about how they can come into compliance. What are the things? What if the person next door is banging on the wall all the time? What if you just gave them a blanket 3-day eviction notice and you didn't know that person can't stand that person because they got a pet and I didn't get a pet, so they're banging on the wall every time. So make sure that you talk to that person and figure out what's going on. Why is that noise occurring? Why is it reoccurring? So make sure you go through that interactive process. I want to make sure am I staying on time? Okay. Yes, question in the back. So the question was, if we have a restricted breed list, are we required to accept the person with a service or companion animal that has an animal on that restrictive breed list? If I come into your housing and I am sight impaired and I have a seeing eye dog that's typically a German Shepherd, are you going to deny me my service animal? No. You are going to help me. Why? I first want to know, why do you have that restricted breed list? Is it insurance? Typically, yes. Or it's city, state, or county code. And you're going to help me apply for a reasonable accommodation to either the insurance to waive that policy for my seeing eye dog, or you're going to apply to the city, the county, or the state for a reasonable accommodation for a waiver of me having that animal. That's what you're going to do. If it's a companion animal, you're going to get a proof of need, that they have a disabilities defined under the Fair Housing Act, that they need that animal to use and enjoy the dwelling, and then you're going to go through the same process. So you get the layer in there is the proof of need, and then you're going to ask the insurance company or the city or the county or the state for a waiver. Yep. Question in the back. There you go. Okay, so the response to that was, it's not a restrictive service animal list, it's a restrictive pet list. Okay. And so some of it is educating our community about applying those, but also insurance companies. So be mindful of that. It's an opportunity for you to be the fair housing educator. Oh, what do I do if my service animal has the litter? What do I do, right? Well, I want to say that the litter is not considered a service animal, okay? I have never ever seen a qualified professional, person in position to know, say it was. Now, I have to remember those disclaimers. There will be the case, but I haven't seen it, okay? But what I am going to say is be humane. I talked with Terry Kate about this, one of the best fair housing provider defense and attorneys in the country, and she says be humane. Let them be weaned. Can you enforce your damage policy? Can you enforce your pet policy to charge a pet deposit? Yeah, but usually people have been humane about it. Don't force them to get rid of their service animal. Give them time to address it. Yes, you can charge for damage, okay? unless there's very rare circumstances, but engage in that interactive process when a mistake like this is made. Okay? I'm wrapping up here. Okay, can you require shots and license? Yes, if it's required by city, state, county, but you can also ask for a waiver. Typically not rabies. There's probably no one that's going to say you can waive a rabies shot. Can you require insurance? No. Okay, again, if it's a financial barrier, ask for a reasonable accommodation. Okay. Can you require them to be spayed or neutered? No. What if you make them kill their animal or it's a financial burden? Decline? No. Please don't. Again, financial burden. What if the decline kills their service animal, typically their cat? Be on a leash. David answered this really well. If it interferes, yes, they have to be under care and control. Yes, if city or state or county code requires it, you can ask for a waiver if it will interfere with that service animal's ability to do his or her job, like detect an epileptic seizure or a diabetic anaphylactic reaction. And please don't require cats to be on leashes. That's silliness. I've never even seen. I'm just telling you. These are my favorite questions, and they all have the same answer. They all have the same answer. What if a reasonable accommodation or proof of need letter looks questionable? What if the proof of need provider writes one for everyone? What if the proof of need letter doesn't say the person has a disability or needs the accommodation or doesn't provide the connection to the disabling condition? Or what if it's 5 years old and looks really suspicious? Or what if they got it from a California service animal shop? Okay? Those are all the same to me. Those are all the same questions. No one in their right mind wants us to misuse or abuse the law, because I can't even tell you how effective a service animal is. You're going to see them everywhere. We have so many people, but the most compelling thing that I can tell you is for children and persons with disabilities and veterans returning from serving. It is more effective than medication. A lot of times it's more effective than a doctor. And so for us to not welcome service animals in every facet of our life, we're here to stay. Let's move beyond that. Make sure that you're creating quality housing, like the Thomas development here, that can withstand anyone living in it. Everybody has a lot of wear and tear, no matter what walk of life you are. So make sure you're making housing green, affordable, accessible, all those sorts of things. If you ever have doubt about a proof of need letter or a need, please contact us. Please contact HUD. Let us be the mediator to help you resolve it. A lot of you have asked for our help, and be brave. Charles is here for that, Christina, John. We want to make sure people are included in housing and not excluded. Okay? And then if you have a visitor, okay, this is the last one, and then I have some scenarios, but I'll let you go through those so you can test your knowledge. Those are like your own tests. Can a visitor, are they required to have a reasonable accommodation? Well, if they're just coming, let's say it's just an occasional, no, you're going to let them in and they can have their service animal because it's a temporary thing. If they come a lot, look at a case-by-case basis, but if it's an obvious disability and I have a sight impairment, you're not going to make me get a reasonable accommodation for my visitor. But you might if it's not obvious, right? This is an answer directly I got from Christina because we keep having this. Reminding you, too, that in Idaho, it is a misdemeanor, is a criminal misdemeanor to interfere with an ADA-defined service animal. A criminal misdemeanor. Okay? Okay. I set up some case studies, and please make sure you have, I want to make sure that we answer questions if you have any more. But make sure you go through these. These are directly from the Baselin Center, which is a great resource, and also our HUD DOJ statement, which was an awesome document written by HUD and Department of Justice. Any other questions? We got a question right here. She has two questions.
The first one is, what if we have a tenant that we find has restricted or violated the pet policy and they have not provided proof of need, and when we bring our 3-day notice to them saying you need to get rid of the pet, they say, oh, I'm so sorry, it's my son's friend's dog, we'll get rid of it. And then the next day they show up with a proof of need.
Mm-hmm.
I understand that obviously the most recent is that it is a service animal, but is there anything that you would suggest to do after that, or just
Okay, so the question was, someone moves in, and they go visit them, and they see that they have an animal in their housing unit. And the animal, the first time they talk to the person, the unit is her son's friend's animal. But then a few days later, they come in and say it's a service animal, right? It's their service animal. Changes from a pet to a service animal. Okay. Again, giving the lawyer disclaimer, I would say that I would contact your attorney or us or HUD, because if it's blanketly questionable, I would get someone to intervene on a mediation to make sure that it really wasn't, they thought they had to hide what it was, and so it really was their service animal. But if they're really, it's not, and they're just trying to get the animal in because it's a pet they want to have, I would get someone else to help intervene so you don't face a fair housing complaint. That's what I would do.
And then my second one is, I have a tenant who has a service animal with their puppy, and then later we caught them with a pet, a separate dog, and they said, oh, here's my proof of need for them, and the doctor says he needs a service animal for his service
Oh, good, okay. Oh, thank you. Oh, I forgot, that was one of my frequently asked questions. I gotcha. Okay, so the next question was, what if I have well, we'll give you the facts first. This is the fact scenario she gave me. She has a service animal. The person has a service animal, one of her tenants, and there's also a pet. Then a couple days later, she has a proof of need from a doctor that says the one animal needs a reasonable accommodation for the second one. Okay? Reasonable accommodations apply to persons. They do not apply to other animals. So you can't have a service animal for a service animal. Okay? But if it's like the Janish case, remember the two-cat case? Where together, maybe it was inartfully written by the qualified professional, if they together work on something or two disabling conditions, maybe one provides mobility. When you can't operate a wheelchair any longer, they pull the wheelchair, while the other addresses an emotional PTSD, bipolar, schizophrenia. They might have two service animals, and they might be able to document it by their qualified professional. So it could be that situation, or in this case, if it is a service animal for a proclaimed service animal, then it is a misapplication law. Again, please use all your good mediation services or resources in your community to problem solve it, because I guess what I want to say to you is probably over 80% of our cases are service animal cases, and when they are not mediated, when we have to pursue a fair housing complaint, we typically, or go to court, they're typically between $5,000 to $20,000, $25,000. And there's one case in the country where it was $324,000 for a service animal violation. So they're very expensive, and I think that sometimes it's these innocent situations where she's trying to do the right thing and she's trying to problem solve it, and we don't reach out to somebody to get help. Get help. Have someone help you mediate it, because that's the best thing you can do. There's really good resources in the community right here. So that's really good questions. Anybody else? Question right here. So the question was, she's a realtor, and you also act as a property manager too? Oh, circular. So someone, you're showing the house? Okay. So she's showing the house, and I'd have to have more facts and circumstances, but I'm going to assume, let's just say in this case, this person has a support animal, and they go to visit the home. Okay? This can get complicated because let's assume, I'm going to assume facts, not in, lawyer, assume facts, not in evidence, that the person doesn't have a disabling condition, the seller, okay? I'm going to assume they don't have a disabilities if under the Fair Housing Act for some allergen related to service animals. Let's say they just don't want animals coming to visit when you're showing the home. But if a person has a seen eye dog or comfort animal that they just can't go anywhere else with, and you deny them access to seeing that home, it could be a fair housing violation. I'm not saying it is on the seller part. If the realtor acts in conjunction with that seller and you say, nope, I can't show you this house because they don't want anybody with a seeing eye dog, you are actually aiding and abetting in a fair housing violation. So you want to educate, listen, you want to educate that seller that I'm sorry, I'm a fair housing provider and I can't deny someone access to seeing your house that has a seeing eye dog. How can we accommodate the person? Because you also don't know if that seller has a disability defined under the Fair Housing Act. And so you might have to mediate that because maybe that animal might pose a health threat to them as well. So you want to make sure that when you have two competing needs, when you have two competing disabling conditions to get, we have mediators that help us all the time with those cases because all parties want to do the right thing. The realtors want to do the right thing. The homeowners association wants to do the right thing. The seller and the buyer want to do the right thing. So get someone to help you. Okay, we have 4 minutes and then I'm cut off. Oh, it's 4, I'm cut off. Can I still talk to the people in the audience? Okay, okay. One more question. Yeah, companion animal applies to the sales of homes. Yep. Thank you guys, you're awesome. See you tomorrow.